Welcome. Can everyone hear me if I talk at this volume? Thanks for coming so much. We're really excited to start U-PRISE. We know it's a little wordy, but we tried really hard to come up with a great acronym. So Parent Resources and Information for Special Education. Hopefully you got some of our emails that came out. We also started a Twitter handle, so you can follow us on Twitter, and we also have a web page, and we can show you where all that is. It's off of our special ed page. There are refreshments for you if you need anything or want anything. There's coffee, waters at your seats, and there's cookies in the back. If you brought your children, if at any time you hear them, feel free to go check on them. But we do have wonderful NHS volunteers here tonight who are watching your kids. So happy to have that service so that you can attend tonight. Just to do some introductions, I'm Shannon Brown. I'm supervisor of special education for the district.
Hi, welcome everyone. I'm Leah Ryder. I'm the Director of Special Education.
Hi, come on in. Welcome. And we can let you introduce yourself as well, and then you'll speak later.
Yes, I'm Pat Bergmeyer with 1847 Financial. I do financial planning for special needs situations.
So Pat is part of our guest speaker series. So each month we'll have a different speaker or a group of speakers who will be here. And so this month we'll do financial planning with Pat. So we're happy to have him here. Just real quick, we wanted to give you an overview of our, Leah will give you an overview of our special education programs, and then we'll talk about U-PRISE real quick, and then we'll get into the evening.
So just a little bit about special education here in Unionville Chadds Ford. As with everything in the district, we're very proud of the programming. We feel that it meets many of our students' needs, and we are flexible and willing to work with our students. As Shannon said, we do have a hopefully updated website for you to be accessing. We worked with Dave Lissman, who's sitting in the back. He's part of our communications team here in the district. Our special education services, we do run the continuum within the district, but we also work with our intermediate units and at times our approved private schools. We do run programming for students with all disabilities across all of our schools. Very recently, if you've been following our board meetings, we expanded our programming to include life skills, which is now K-12. It had been 6-12 for a very long time, but we just opened an elementary program. We run learning support K through 12, we run emotional support K through 12, and we run autistic support K through 12. We do also have social skills programming, speech and language support, occupational and physical therapy, and just this week our new board certified behavior analyst started in the district. So we're always continuing to look at our programming and our students' needs and explore ways that we can provide additional supports and services both to our students and then to you as families, which is really where U-PRISE started. So you can feel free to sort of look through all of the programming that's offered. I didn't mention we do also have a multiple disability support program in the district. It's actually run in conjunction with the Chester County Intermediate Unit, and currently that's a K-5 program. But as our students age, we will look and see how we can continue to support them as they get older. So in front of you are also business cards for both Shannon and I. So if at any point in time you have questions, concerns, feel free to reach out to us. Our offices are here in district office, and we would be happy to speak with you via phone, email, or in person. So welcome. We're very excited to start this series, and we hope that you find it as informative as we have.
Perfect. All right. So just to talk a little bit about U-PRISE, the goal is basically to provide you, parents of students with disabilities, with education, with resources, with networking with other parents, trying to give you, hi, welcome, come on in. No problem. Just trying to enhance our partnership with you between the district and the community and parents, who are obviously, we're all part of that community. So we want to serve as a voice for our students with disabilities. We want to talk about hot topics. We want to talk about what's going on in the district. I can tell you, for our guest speaker series, we're really trying to get in touch with, we have an advisory committee, and any of you are welcome to join that advisory committee. And so there are subcommittees, so planning, communication, community resources, school parent liaisons, and then there was a speaker committee. And so they gave us feedback about what parents wanted to hear about. So that's why Pat is here tonight. In October, we're going to talk about technology. That's all the buzz, our new Power School system that we just got for IEPs, which many of you, you should have all received an email from Dave. Was that yesterday? Just yesterday, about how to log into Power School to access your students' documents. So that's different than systems we've used in the past, so we're really excited about that. So we talk about that and talk about assistive technology. We have different people coming In November, we're going to talk about behavior. Leah mentioned we have a new board-certified behavior analyst, so he'll be sharing behavioral strategies. And Ginny Covort, our medical access coordinator, will be coming also to talk to families about how you can get medical access supports if you need them and what they can do for you. In January, we're going to talk about executive functioning. We are one of the school districts in the county that's up and coming, and the fact that we have an executive functioning curriculum from Dr. Bosday. It's a research-based curriculum that we're really happy to be using K-12 this year. So we just went to see her speak at the intermediate unit this past week, so that was really exciting. So some IU staff will be coming out and some teachers to talk about that in January. In February, we're going to talk about social skills. That's always a hot topic, so we'll have people coming out to talk about that. In March, we're going to talk about transition. Sorry about that. We're going to talk about transition. So we'll have different people from the IU and also our transition coordinator in the district to talk about transition. In April, we're going to talk about related services. So we'll have speech therapists. Hopefully, we'll have occupational therapists from hostels and physical therapists. And we'll also have hearing and vision staff from the intermediate unit. And try and talk all about related services and answer questions. And then in May, I believe we're going to have a past special education parent, actually, who's a psychologist in the county, coming to talk to us about how you talk to your children about their differences. And so we're really excited, and we'll hope to end in the summer with a community resources fair, having Special Olympics representatives come out, YMCA representatives come out, different people in the community who have things that they can offer your children, so, and offer you as a family. So we definitely, if you have any feedback, feel free to reach out to either Leah or I, or email, or if you want to be part of any of the subcommittees, to help us plan, to help get the word out. If you ever get an email, if you're part of some community activity and you want to share it with the group, you could let us know and we could post it on the website. And then we do have school parent liaisons. Penny Johnson is our current school parent liaison, so if you ever had questions and you wanted to reach out, she's a parent of a child at Hillendale in a special needs program. And she's very willing and eager to talk to any parent who'd like to talk to her who had questions about the district. If you're new or you just, wanted to talk to another parent, she's a friendly parent that you could speak to. And if you wanted to volunteer to be a school parent liaison, we'd be happy to have you do that as well. Just so long as you like us and you say nice things. All right. Let me see real quick. I'll try and open this. So on our special education, does everyone know how to get to the special ed website? I can show you. So if you go to ucfsd.org, that takes you to our district webpage. It's showing up a little big on my screen, so I apologize. But if you go to departments and then go to special education, that brings you to our webpage. And then on the side is information about U-PRISE, and there's also information about Power School Special Ed, which is where you can access your child's IEPs, evaluation reports, things like that moving forward. And there's directions on there of how to do that, but I'll go to U-PRISE today. So on here is where we have our information. All the meeting dates are listed on here. I hyperlinked the flyer. Our Twitter is on here if you wanted to follow us. Guest speaker information. And our school parent liaison's email is here if you click on that. So we'll try and keep this updated for you so that there's information there as the easiest way to access that. All right. Does anyone have any questions about U-PRISE at this point in time? If you're interested at the end and you want to be on a committee, you can just come up and see us. Our next advisory committee meeting is October 6th at 11:30 right here. And our next general meeting is going to be October 26th, and that will be the one that focuses on technology. And real quick before I let Pat speak for the rest of the evening, just some community news resources I wanted to share. If anyone's interested, Special Olympics bowling is just starting up. If any of your children are interested, I can share this information with you afterwards, and it's also, we'll link it on the website afterwards. You can access it too in Downingtown and Oxford, and they have all the contact information for you here. Also, the Chester County College Fair, if anyone's high school age, will be going on at, I believe, Exton Mall. Yes, Exton Mall on October 31st. So that information is there as well. That was the only community news I had at this point. I believe your wife shared community news with me, but it expired, so I didn't share. I wasn't quick enough. All right, so then I will let Pat take over and talk about special needs financial planning. Did everyone get one of his folders? Did anyone need a folder?
Yes, should look like this. Everybody have one?
Okay,
All right, great.
great.
Pat also had a sign-in sheet to collect your information that was going around, so if you didn't have the opportunity, you could just make sure to fill that out so that you can communicate it needed.
Okay, so I'll minimize this.
Question. One of the themes you mentioned was transition.
Yes.
What do you mean by that?
So transition, we will probably talk about not only transition from like elementary to middle and middle to high school, but also post 21. So transition goals, so employment, independent living, post-secondary education and training. We also will have someone from the IU come and talk about some of the programs we have. We have the IU has a transitional living program, a transitional work program, Aspire, which is on Westchester's campus. We have students who learn to go to college out at Aspire before they actually go, but they are enrolled. So that's a very interesting program that we have. Discover programming that we have for that age range, 18 to 21, where they have a job coach and a mentor, and they sort of learn how to work in the workforce. So sort of all of those types of opportunities. Mm-hmm. All right, Pat, I will put this up for you. And I will also for each month, like you got the flyer today for today's event, and it talked a little bit about Pat, and on the website there was a link that let you see everything that Pat was going to talk about today. We'll try and do that for each one. So for the transition one, there'll be a link on the website, and you can see the specific details of what each speaker will be talking about.
Shannon, do you want to share that it's being recorded?
Oh yeah, and also we're recording these sessions, which is why Ryan is here. Thank you, Ryan. Ryan works for technology for the district, and so we'll be also linking these on our Special Ed U-PRISE website. So if you can't attend a meeting and you really wanted to, you could always log back in to the website and just watch it from home in your PJs. Okay?
Or share with your friends that weren't able to make it.
Yeah.
They can watch me in their PJs. That's fine. First of all, I want to thank these ladies for inviting me in. I really feel honored to be the first presenter at the initial meeting for U-PRISE. I feel there's a ton of information that always goes out there. I'm sure you guys as parents almost are at the point of being overwhelmed with, what to go to. This is the busy season for all kinds of conferences, no matter what your child's diagnosis might be. So I appreciate you taking the time to come out and, listen to me for, how much time do I have? 45 minutes?
What time is it?
It's 6:30.
It's 6:30. You have about half an hour.
Half an hour, perfect. So I'm going to do the condensed version of the workshop that I do to try to get you guys as much of the critical information that's involved with special needs, financial, estate, tax planning. In your folders, you have a couple things. You have our team's brochure. My contact information's in there. My partner Lori is over here in the crowd. There is also think of this as like the Cliff Notes version of what we covered. 10 basic steps, where to get started, where to, if you've done some planning, no planning, but some of the key takeaways from the presentation. And then there's a workshop evaluation. In a nutshell, what this is, I'm going to talk about a lot. I'm not going to go into detail about everything, but there's a bunch of common, what I've found, concerns, frustrations of parents. If you have a chance to go through this and you want to give this to us, let us know, number one, how we're doing with this workshop. If there's other topics that you think would benefit the family population here at Unionville, well, Lori or I will collect this from you. But also, there's one question on here. The first step in this planning is really coming and understanding what goes into this process. Our first meetings are always complimentary. Should you want us to follow up with you and find a time to sit down and talk about everything that we covered at a high level and how it applies to you personally, you simply circle yes. And what that means is Lori or myself will follow up with you to try to find a time to get together to have a conversation. That doesn't mean we'll chase you around for 6 months to try to get you to commit to that meeting you wanted to do, but really we'll follow up with you to continue these discussions. You circle no, you won't hear from us. We'll probably add you to our email distribution list. That way, anytime anything like this is going on, conferences, at least you're aware of the information that's going on in the community. All right? So quick background on me, if you didn't read the bio. I've been focusing my practice for the past almost 8 years now on financial, estate, tax planning for families that have loved ones with disabilities. I've been doing financial planning I'm in my 12th year. But what I realized when I first got exposed to the depth and sophistication of special needs planning is how many mistakes can be made by, you think of your common attorney, your common financial planners that don't understand the dynamics of what goes into a special needs situation. So the problem I found in almost 8 years is there is no manual to this. Now, I'm sure you've tried to find the IU's manual on financial planning for an individual with a disability. You won't find it because there is no one size fits all. And just so I get to know where you guys are at a little bit better, just to know where your children are, by a quick show of hands, who has a loved one in here between, say, the ages of birth and 5 that have special needs? Anybody? How about 5 and 14? A lot of you. 14 and 18? How about 18 to 21? Anybody? Over 21? No? So those ages I pointed out are all the critical ages of where we need to do different levels of planning. Somebody had asked about what does transition planning mean. Some of you have already experienced a couple transitions. Transitions from early intervention into the IU into the school district. There's going to be a big transition that eventually comes at either 18 or age 21. That is the big one. That is the one that keeps a lot of families up at night, because that's where, have you ever heard of the cliff that you fall off of? All the entitlement benefits that you've been receiving since your child was diagnosed with a disability and then you get into the school system that are covered by IDEA, they all end. So at 21, it's a cliff. You fall off the cliff of government benefits, and then really the responsibility of navigating this system for your now adult child falls on your shoulders. And our goal through all these life transitions are to make them as smooth as possible, not only for your child, but also for you, for the other family members that are going to be involved. And the key to all of this planning is to make sure that lifetime care and quality of life for your child is maintained. And the government benefits that are also so important to not only get but keep are not jeopardized, and that you can still have the semblance of a retirement that you've always wanted. And that Uncle Sam, at the end of the day, takes as little of your estate as he possibly can. That's kind of a perfect plan when it comes to special needs planning, that you can do what you need to do, your child is taken care of, the benefits that are available to him or her are maximized, there is no extra responsibility or burden put on other family members, everybody is taken care of as equitably as possible, and Uncle Sam has no involvement. The problem is it's not as easy as it sounds. So what I like to do is kind of give a 30,000-foot overview of what goes into this type of planning. And, you know, what I've found is families have a lot of questions. There's a lot of good information. I want to commend the district of providing a venue like this, a group where you can go and talk to other family members or other parents. You don't have to reinvent the wheel with things. You can learn from other parents that have been through some of these things, that have embarked upon transition planning, that have navigated 1 or 2 IEPs in their life. So you don't have to, make any mistakes that they might have made. And what I've found is there's not a lot of districts that do something like this. A lot of districts are afraid of, opening up a venue for parents to come in and talk about it. So it's impressive to see this happening. So special needs planning is going to consist of 3 main areas. And before I go into some of the things from a legal perspective, anybody in here an attorney? Okay, we've got one. Thank you. We've got a good resource in the room. Do not take offense to anything I say about attorneys during this presentation. Is anybody married to one? No, we got one wife. Okay, so good. You'll see that there are experts in the area of special needs planning. There are experts in the financial side, there's experts in the tax side, and there's experts on the legal side. And unless you do this every day, unless you're doing special needs planning as the focal point of your practice, there's a lot of mistakes that can be made. And commonly I see them in the legal side of this planning. So the first area that families are going to gravitate to is, I need to do certain type of legal planning with an attorney. The problem is any attorney can technically do the special needs estate planning work that needs to be done, but it doesn't mean they should be. You want to do the estate planning with somebody that does this every day, an expert in the special needs side. The problem is just doing estate planning, just having legal documents in place does not mean you are done. Because the second area that you need to look at is the financial side, is that eventually these legal documents you've created will be used, that they will be funded adequately. There will be enough, always call it stuff, enough stuff that goes into these legal documents to take care of your child. And then the third part, which is the emotional part of this, the day none of you ever want to think about, which is the day when you're no longer here. So you're gone. The assets that you have are in these legal documents. Now what? Who replaces you? Who continues advocating for your child? Who's there to navigate an ever-changing government benefits arena or IEPs? Who's there to physically check in with them on a weekly basis to make sure where they're living is a clean environment, that they are having quality of life, that all of their benefits are being maximized. So the third part of the planning, which most families don't think about, is the one that's going to coordinate a plan of care as you're aging and as your child is getting older. That way, say your neurotypical children aren't the ones that are shouldering all of this burden that they haven't been doing it their entire life. So you have a legal plan, you have a financial plan, and you have a plan that is going to control the care and take care of the care for your loved one as they're an adult. So you need all three of them to, in my opinion, to have a comprehensive plan. So what I'll talk about here, and again, going through the main pieces of this, and just do this the long way. Here's some of the important things that we find. The one key here, it's hard for me to sit down in one place. So 3-person retirement. That is the biggest thing that makes this different. By a show of hands, how many people in here think your child is going to be relying on you to some extent when you are in retirement? Who doesn't know yet? So it's an unknown. But for those of you that raise your hands, we don't know where your child's going to be as an adult. But chances are they may be financially dependent on you to some extent. So we need to build that into the retirement plan that you have to say, what are the unknown expenses that I might still have to pay for, even though my other children are out of the house, but my child with a disability is not. You know, is there extra care? Is there a rent subsidy I need to give them so they can live on their own? These are all things that take the traditional financial planning and put it, do a 180. How we invest, where we invest, the type of risk tolerance that we have. It's all different with special needs because you're planning for 2 lifetimes. It's not just mom and dad having enough money to live off of for the rest of their lives. It's mom and dad and potentially a lifetime beyond. So it changes how you approach your financial planning decisions. It changes legally how you're going to set things up for your other family members to protect the wealth that you leave behind to make sure it eventually will stay in your family and go back to your loved one with a disability if it's needed. So there's different things you need to consider with special needs that you don't typically think of when you don't have a child with a disability. Some of the issues that I've found in my travels is, there's a lack of coordination amongst the advisors you work with. Your attorney never talks to your financial advisor, who never talks to your insurance advisor, and that could cause some major gaps. The advisors that you maybe work with aren't experts. This is more so in the legal side of things, an attorney drafting special needs documents that doesn't do it often enough. Plans that haven't been opened up or dusted off in a number of years. And I think the biggest thing, which is we're all guilty of, and there's a saying, we spend more time planning a vacation than we do our finances. It's procrastination. I'm too busy right now. Sporting events, IEP season, it's the holidays, it's summer. There's always an excuse that we can push things like this off, which is why attorneys and financial advisors do not have a line waiting outside their office on Monday morning for people to come and talk to them. But it's important. And the reason is families will ask, well, when do I need to do this? And all joking aside, it's one day before you die, because we get one shot at it. And honestly, it's too important to mess up. And if we don't do it proactively, it could cost our loved ones hundreds of thousands of dollars. So, if you have a younger child, even if your child is higher functioning, we've had clients that have children with Asperger's that families have decided not to take planning steps because they're going to college, but then college doesn't come to fruition, or they can't, they don't graduate, and then they try to get a job and there's no jobs out there. The job market's not good, not a great job market if you don't have any special needs, but if you do, it's not easy to find a job that provides gainful employment. And if we wait and go past certain ages, then we could lose out on government benefits for the rest of their life. So don't let any of those common excuses get in your way from doing the proper planning. I'll skip through these questions I'll come back to. We talked about these 3 main areas. Basic estate planning documents, we'll talk about the importance of each one, but these are basic. People think of estate planning, they say, well, that's only for the super wealthy of our country that need to do an estate plan. It's not. Every single person needs to have an estate plan in place. It is crucial for those of us that have minor children, and it is extremely important and necessary for anybody that has a child with a disability. You need a plan in place to spell out things to go in certain ways to the right individuals. So your basic documents that you should have. and I'm a big fan of audience participation, is after a whole day of work. How many people in here have a will? It's okay if you don't raise your hand. For those of you that did not, guess what? You actually do have a will. And guess who gets to create it for you? The state. How many of you that did not raise your hand want the state to decide who raises your child? How many of you that didn't raise your hand are married? Do you know that you could accidentally disinherit your spouse if you die without a will in the state of Pennsylvania? So these are all things that we don't think about. But the importance of a will when you have a minor is to simply name who is going to be the guardian of my minor child if my spouse and I passed away. It's a very important decision that I would imagine all of you want some input in. If not, the courts decide. And it could cause some bickering if you have two loving families on both sides fighting over who feels they are best suited to raise them. In Pennsylvania, if you're married, you're entitled to the first $30,000 of your spouse's estate and then half of everything else. The other half goes to your surviving children, which could be a disaster for government benefits planning. So it's important to have these things in place. A will is simply a fancy way of saying who gets what and when. Now, it's protecting wealth for future generations. It's protecting wealth for our children. And mainly it's to make sure things can go privately, if we can, to those that we care about. So basic documents. Who had a child approaching 18? Over 18? So none of you have to worry about this now, but at 18, you're going to have a very important decision to make. Just know you are not forced to make one or the other. You have to make a decision to still be involved in your child's life from a medical standpoint. And you're either going to go through a guardianship hearing, or you can have your child sign over a power of attorney. As you approach 18, this is a conversation to have with an attorney that's going to educate you and advise you on what's the best fit for your child. What you do not have to do is absolutely go through a guardianship proceeding for your child. And what that is at 18, you take them to court to petition the judge to declare them mentally incompetent, to take away all the freedoms and independence that you would have been fighting for 18 years, just to have a say in their life. So hopefully by the time your child's 18, they maybe have another option we can look into, but it's not an issue until they turn 18. If you have friends that have children approaching 18, tell them as well, they do not have to do a guardianship proceeding. Guardianship is a $2,500 to $3,500 legal expense. A power of attorney could be a couple $100s. Either way, you need to make a decision. Does anybody have children off of college right now? No? When you have your neurotypical children go off to college, you should have them do powers of attorney. If they go away at college, they get hurt, and they cannot discuss their medical care with their doctor, a power of attorney for health care is the only way that they can. So they will not talk to you when your child's over 18. Trusts, there's many types of these. They all have many different purposes. I will talk in a minute about a very important one, but a trust is a protective measure. Think of it as a way of protecting the wealth that you leave behind. It's not a blank checkbook for those you leave it to. You put restrictions on how the money's accessed. You put a hierarchy of who it's going to go to after the person passes away. It's going to make sure your money stays in your bloodline. Rather than if you leave money to your child, they get married and get divorced, that divorcing spouse could take assets that you left to them. The trust we'll talk about here for your child with a disability is the most important legal document that everybody in this room has to create. So on this first question, are you planning to leave over $2,000 to your loved one with a disability? This next slide is probably the most important one of this entire presentation. So my teachers always made it, a point for me when something was going to be on a test to write it down. This next slide. If you leave over $2,000 to your loved one with a disability, they will automatically lose eligibility for most government benefits. Is anybody hearing that for the first time? That number has not changed in 7 years. And if you're that parent hearing $2,000 for the first time, I'm sure you're trying to do the mathematical gymnastics in your head saying, well, how do I provide lifetime care with less than $2,000? But this is the law. This is how this works with government benefits planning. And when you look at benefits, these are probably the crux of the presentation. You have two types. Does everybody in here have their child on Medicaid? Medical assistance, medical access, MA? No? So in Pennsylvania, there is a Pennsylvania Medicaid loophole. Regardless of what you make, regardless of what you have, your child is entitled to Medicaid if they have a disability. That disability can be as broad as ADD or ADHD. We are the only state, at least on the East Coast here that I know of, that has this loophole. So if you have major out-of-pocket medical expenses, or your private health care is not covering their speech therapy or occupational therapy or physical therapy, you need to get your child on Medicaid tomorrow. If you have questions on how to do that, please contact us, but your children are entitled to be on Medicaid.
We have a medical access coordinator in the district, Ginny Covert, and she's going to be at our next meeting in October.
So the key to Medicaid is health care. It is going to be the secondary health insurance behind whatever you have privately, but it picks up copays. But the biggest thing is to get your child in the system from as early on as possible, so you're not scrambling at age 18 to get them into this system. So because of that loophole, it's one of the nice things about, well, there's many nice things about living in Pennsylvania, but Jersey doesn't have it, Delaware doesn't have it, New York doesn't have it. People literally move right across the Delaware border so their children can be on Medicaid. So under 18, it is one of the few means-tested or eligibility-based benefits that your children are able to get. There's another means-tested benefit called SSI. Anybody hear of that acronym? Who's overloaded by acronyms at this point? There's plenty more coming, trust me. ISP will replace your IEP. So SSI is an often confused benefit with Social Security, which it is not. It's supplemental security income. SSI is a benefit that is intended to feed, shelter, and pay the utilities, room and board, for our adults with disabilities. Under 18, they look at what your resources are and what your income is. In most cases, unless you're at the poverty level, your child will be denied eligibility for SSI. That all changes on their 18th birthday. They no longer care what you make or what you have at 18. They solely look at what your child has. That's where that $2,000 comes into play. So SSI, does anybody know what the maximum amount of SSI is in Pennsylvania right now? All right, so let's try to figure it out. How much should it be? It's supposed to feed, pay the rent, and pay their utility bills of our adults with disabilities. How much should it be? Don't make me start picking on people here. Anybody? How much do you think is rent in this area right now for a one-bedroom apartment? $1,000 a month? It's $733 for the three of those things. $733 a month to feed, shelter, and pay the utility bills of our adults with disabilities. We know it doesn't go that far, but it is a benefit that our children are going to be eligible to receive after they turn 18, which is why we cannot accumulate assets in their name under 18. So that $2,000 resource limit, if they have, and we'll talk about resources, if they have anything over $2,000 in their name at 18, they are financially ineligible for SSI. So we cannot afford to do that.
So they include 529s?
Yeah, so I'll jump to this countable versus not countable resources. The list of what is not countable is a much smaller list than what is countable. So what can they own? They can own an automobile used primarily for transportation. So your collectible Lamborghini, I think, is not part of that. They can have personal belongings, musical equipment, video games, things like that. They can have up to $2,000 in their name. They can have ABLE accounts, which are new. They can have PASS accounts, but pretty much everything else is countable. So we'll start with the easy stuff. Savings, checking, CDs, bonds, savings bonds, stocks, mutual funds, IRAs, annuities, life insurance that they own, 529s, Coverdell's, investment real estate. These are all things that are countable against them for government benefits testing, which is why financial advisors that do not understand special needs may not be even aware of this to advise you not to start saving in their name. Some of the things like 529s and Coverdell's are pretty easy fixes, but some of the other ones get a little bit more difficult. The higher the dollar amount that you have, it gets even trickier. And the closer we get to 18, it gets tough. So a quick rule of thumb, no matter where your child is, and this is not a life sentence that they will be disabled at 18, is do not accumulate assets in their name. Keep it simple. Do not give anybody their Social Security number. Because if you give them their Social Security number, they're going to open an account in their social, which we do not want to have happen. This doesn't mean that you tell family members to not save for them. It's just you have to save in the right places. You as parents have to save in the right places for your child. We just can't have it linked to their name. Any questions on that? So that's where this $2,000 resource limit really comes into play. So SSI, if they qualify at 18, is the gateway to continuing Medicaid eligibility after transition out of high school. So at 21 in most cases. So as long as you get $1 of SSI, you continue Medicaid, which is health care, which is a much more important benefit we can't afford to lose, right? If SSI is $700 a month, Medicaid could be paying $7,000 a month in medications. So that's why we can't lose it. All right. There are other means tested benefits like these things called waivers. We could have a whole other presentation on waiver funds. But if you have questions on those, if you have a child that has an intellectual disability, an IQ below 70, come up and talk to Lori and I after this. So the eligibility benefits are means tested. Then we fall into the world of entitlements. These all come under Social Security. How many people contribute to Social Security? That's everybody. If you're working, you're contributing. It's your FICA taxes. There's annoying 7.5% that comes out of your paycheck until you hit a certain amount of income. But what that's paying for is your future Social Security retirement benefit, if it's there, of course. But it's also a benefit that is entitled to your child. So how your child can collect a Social Security benefit if they never work themselves is off of what you contributed. And there's 3 ways. When you retire and you elect your Social Security retirement benefit, they are entitled to half of what you receive, in addition to what you get. Doesn't take away from you. If you became disabled and collected Social Security disability, they are entitled to half of what you would get. And when you pass away, hopefully a very, very long time down the road, they are entitled to anywhere from 70 to 90% of your benefit. And that is the maximum cash benefit they will ever get through the government. So if you're going to get $3,000 of Social Security retirement and you pass away, you're looking at, say, $2,000 that they would be able to get per month. Any question in the back?
Yes, my child entitled to all those benefits, whether they're working or not, or?
The question was, are they entitled to those benefits if they're working or not? That is one of the determinants for even being eligible for these benefits. You have to be deemed disabled, and the definition as an adult is a lot more strict than it is as a minor. You have to be deemed disabled by Social Security, which means that they do not project that you're able to work and make over roughly $1,000 a month. So there are little deductions against countable income for that, but that's the big determinant.
So if my husband and I both work and we assign our Social Security to our son, that he would get 90% of our Social Security?
Question was, do they get 90% of both of your Social Securities? Unfortunately, no. It's the higher of the two, which makes your decision of when you collect Social Security a lot trickier, much different than somebody else that could retire and take it at 62.
But I have 2 children with special needs, so I could assign one to one, and my husband could assign one to.
Well, they would both get half of whoever's higher.
Oh, so it doesn't, because it doesn't take, we would still collect.
You would still get yours, they get theirs. That's how it is today. But again, by the time we retire, who knows what Social Security is even going to look like. We have a $19 trillion and growing deficit and a Social Security system that's full of a bunch of IOUs. So we don't know. We can cross our fingers and hope that it's there. But if you get Social Security, that's the gateway to Medicare. After you collect a Social Security benefit, you get Medicare after 2 years. And that's also health care. And Medicare covers a lot more, and doctors like Medicare a lot more and are willing to accept it than they are Medicaid, which I'm assuming some of you have found out. So the key is we do not want to accumulate assets in our children's name, but that's where these other ages are important. So we know at 18 they become eligible for needs-based benefits, SSI. At 21, they're going to transition out of school, which means all the IDEA entitlements end. At 22, this is the most important birthday. If your child is not disabled, and by definition a disabled adult child, a DAC, by their 18th birthday and their 22nd birthday, they are never entitled to collect off your Social Security, ever. So if you do not get them in the system between 18 and 22, they will never be able to collect off your Social Security, which is why you see a lot of families that have kids that are higher functioning procrastinate, try to go to college, and they put these applications off. They could be costing their child hundreds of thousands of dollars of benefits. So that's why we don't want to wait. We don't want to postpone. I have an adage when it comes to planning. You plan for the best, you expect the best, but you have to have a contingency plan. A lot of what I'm talking about is your contingency plan, because we want your child to work. We want them to go to college, be gainfully employed, move out of the house, live on their own, not be financially relying on you. But if all this doesn't come to fruition, we need something that we can transition our plan to smoothly. And that's where the special needs planning comes into play.
Not sure if it's exactly a quick answer, but if you set aside a 529 plan and you're finding that probably still 10 years away, but your child will probably never make it through college, what is the way that you could get that out of assets in their name? Convert it, or can that transfer at least portion of it into an ABLE account?
Yeah, so the question, I'm just assuming that they can't hear them. What can we do with a 529 account for somebody that's not yet at college age to get the money out of their name? The easy fix is you transition the 529, you change it to a different beneficiary, another child. The second easier way is to take out your contributions. Your contributions are not taxed or penalty taxed. You can take your contributions out at any time. And the third option, which is new, which I'm not advising anybody actually do, is you can convert or exchange your 529 assets into an ABLE account with the 2 states that make it available as of right now. So, but I would not be the guinea pig to do that. PA is not one of it's Nebraska and Indiana or something like that. Florida too, but you have to live in Florida. If you have questions on the ABLE Act, ask us afterwards. We can give you our opinion. So
Medicare is means tested or what?
Medicare is not. Medicare and Social Security benefits are not means tested. Medicaid is, yes. Up until they turn 18. Right now, as a minor, it is not, but on their 18th birthday, it is. So here's some of the common planning mistakes that we see families make that know about this $2,000 resource limit. The first one they'll do is they'll simply disinherit their child. We won't list them as a beneficiary on any accounts. We won't list them to receive anything in the will. The idea being, okay, if they don't receive anything, they'll always get their benefits. The problem is there's nothing there to give them quality of life. And we're kind of relying on the state at that time to do it. So it's not a good fix. What usually goes along with the disinheritance is we give it to a family member who is morally obligated to use it for the individual. So let's give the example. Say little Johnny has autism, and his older sister Susie, the parents decide to leave everything to Susie because she's his older sister, and that's what older sisters do, right? Well, it's a morally obligated gift. There's no legal mechanism saying Susie has to use that money for Johnny. If Susie gets married and her spouse whispers in her ear that we need new cars in addition to the house, that money could be spent on other things. If Susie's relationships goes south and gets divorced, that money could be taken in divorce. If Susie dies and her will says I leave everything to her husband, that money might, in essence, it might never get used for Johnny. So it's nothing against your other family members. You don't want to put a Band-Aid on an open wound. So that's what that kind of is. That's why this next slide, again, of important slides, the most important legal document that everybody in here needs to create. Now, keep in mind that word, create. I didn't say you're going to fund it. You're going to create it. This is your backup plan. Having a special needs trust is the vehicle that would be there to receive any assets for your child should you pass away. That way, this trust can have millions of dollars in it, and not a penny of it, as long as it's drafted correctly, is countable against your child for government benefits testing. So everything that you would leave for their future care, instead of leaving to their name, would be left to this trust. It has to be drafted in a very specific way, hopefully by an attorney that does it all the time. But it is a document that we all need. And how we can create it, if we want to create it, if there's other family members that might want to do things for your child, grandparents, godparents, you can create that trust today so it can be funded. They can gift to it. They can leave it in their wills. They can create life insurance or leave their IRA beneficiaries to their special needs trust, and it doesn't jeopardize their benefits. We can create it in our wills, which means it's not here today, but in case we passed away, it gets created. So it's like that catastrophic event would create this. That would be if you don't expect anybody else to do anything for your child before you were to pass away. But either way, you need to do it one of the two ways. And having a special needs trust does not, again, say your child's going to be permanently disabled. It's just having that backup plan in case the perfect situation doesn't come to fruition. Okay? There are two main types of special needs trusts, which get a lot of confusion out there. Semantically, when you look at the legal definition, a special needs trust applies to a first-party special needs trust. A first-party special needs trust, also known as a self-settled special needs trust, is funded by the disabled individual, him or herself. This usually happens in the event of a malpractice settlement, or unfortunately due to an accidental inheritance, where somebody that is on benefits like SSI and Medicaid comes into an inheritance from a family member. Let's say they receive $200,000 from an uncle. Well, they'll lose their eligibility for SSI and Medicaid unless that $200,000 goes into this first-party special needs trust. The money goes in there. Benefits will essentially continue uninterrupted. The trust itself can provide for anything for the sole benefit of the individual with a disability. So, quality of life things that the government's not paying for. The problem is when that individual dies and the money that's left in this first party trust, guess who gets reimbursed first? I'll give you a hint. It's not your family members. The state. On all first party trusts, there is a required Medicaid reimbursement. So every dollar of Medicaid your child ever received from birth, the state gets reimbursed first from these self-settled trusts. So hopefully none of you ever have to create one of these. I call it an accidental special needs trust. It's usually created when an accidental inheritance comes into the picture. But if we're proactive, we create ourselves a third party or supplemental needs trust. These are trusts that are funded by anybody besides the disabled individual. So you would put money into it. Your parents, grandparents, siblings, anybody besides a disabled individual would put their assets into a third-party special needs trust. Same thing, not countable for benefits, can pay for anything for the beneficiary within reason. There's certain exceptions. But guess who gets the money when the individual dies from a third-party special needs trust? Whoever you want. Could come back to you. It could go to your other children. It could go to your favorite charity. You list who the remainder beneficiary is on a third-party special needs trust, which is why that's the type that you would create. So if you do some research, you start Googling these things, you talk to other families, there's a lot of misinformation. They hear special needs trust and they say, well, I'm not going to fund this. It has to go back to the government. That's only one type. The type you would all create is a third-party one, which has no requirement to give anything to the government. Any questions on that? Choosing the trustee, one of the many hard decisions you're going to have to make. The trustee oversees the trust. They control the purse strings. So no pun intended, you have to trust the person. Mind you, it is a job. If you do not want to give that job to a family member, they are corporate trustees. You can use banks to be the trustee. There are a couple of nonprofit organizations that actually focus on being special needs trustees. Either way, it's a hard decision to make. It's a lot that goes into choosing your trustee. And when should it be funded? Remember, I said you're going to create this trust. You don't necessarily need to put a dime into it. Nothing needs to go into this trust from you as parents until the last caregiver passes away. Because as long as mom or dad are here, you will be financially taking care of your child. You'll be paying for lifetime care, any care they need. You'll be giving them quality of life. It's just when you pass away, the trust financially replaces you to continue doing all of that. So some of the hurdles families will face, they'll sit here and they'll try to quantify what their child needs for the rest of their life, which is usually a 7-figure number. And they're like, I don't have that sitting in a savings account right now, so I won't do anything. You don't need to put it into the trust. You simply need the trust there just in case something catastrophic happens to receive the funding at that time. But you could have other people put money into it, which is a great way to get your other family members involved.
You did say that this third-party trust can be created by the death of the primary caretaker, right?
Yeah, so the question was, can these third-party trusts be created at the death of the second caregiver? Yes. In your will, which is only read when you die, the courts would read it, the trust will get created, then everything for your child would funnel into the third-party trust. No, it's a...
Then it will not be eligible for the 2,000 limitations that mentioned earlier.
Correct. Anything that goes into a properly drafted third-party or supplemental needs trust is not countable for government benefits testing. When you are not a U.S. citizen, there is different tax planning you need to think about. It stays the same. It's just it could be taxed differently, especially if you're married to a U.S. citizen and you are not. There's different taxation you need to. That's a whole other trust that you need to create. So, question in the back.
How difficult is it to change your trustee once you state someone? Like if you pick someone and then you find you're not really the greatest person 10 years down the road.
So the question was, how difficult is it to change stipulations in a trust once you create it, like removing a trustee? This is why we don't write these things in stone. There's always a clause that gives the grantor or the creator of the trust the option to remove a trustee or some sort of trust protector if the trustee is not doing the right thing or no longer living, to replace them with somebody or an entity that is. Trust can be created revocably or irrevocably. Simply means that you can completely redo it or you can only change certain things.
Is it advantageous to name more than one trustee?
Yes, you can. The naming more than one trustee is prudent, especially if you're choosing a person. I would have co-trustees. I would not go more than 2 people because then you got to get all those people to agree and at the same time, which can get cumbersome. You can have a person, a family member, with a co-trustee as an entity, a corporate trustee, which is not a bad idea. So the corporate trustee handles all the day to day. Your family member knows you and knows your child. They know what you would have wanted to distribute assets from that trust for. So it's a very complex document. Special needs estate law is not something you can just dabble in, which is why, and I'm not an attorney. I guess I should make that a disclaimer. I'm not an attorney. I can't draft legal documents. I can't give specific legal advice, but what we certainly can do is get you attorneys that we know do this all the time, that are experts, so you can interview and see who the best fit for your family is. So, for the sake of time, this is just really briefly identifying a care provider, one of the other many hard decisions you're going to make, because even if you appoint somebody, they don't necessarily have to do what you want them to do. But there is something that you can create that will give a path for them to follow. It's known as a letter or a memorandum of intent. And what this document is, it's a day in the life of your child and then the hopes and the dreams that you have for them in the future. You know, things like doctors' information, silly things like shirt size, pant size, fabric they might not like to wear, their routine, how do they like their sandwiches cut, what book do they like to be read at night. All the things that you as parents have up here and all the things that you envision in the future for them, you put it on this piece of paper. Because if you died, you want the people that are going to be controlling the purse strings on these trusts to know what you would have wanted. You know, what kind of working situation you would want, what kind of living situation you would want. What are your thoughts about religion, about marriage? These are all important things that as parents you would want to have a say in, even if you're not here to have it. So I've seen some short, I've seen some thick. Some families or parents do it video form each year. They just get in front of a camera and say, "This is what I want." And it's a living document. It'll change constantly as your kid gets older. So one of the things on the evaluation form is if you want a template for that, we can email it to you. So, all right. So those are the first and third area of planning: the legal, which is confusing in itself, and the care management side of things. So the care management, the letter of intent or memorandum of intent, will help guide the trustee on what you would have want money to be spent on for your child, and the level of care and who's going to, fulfill that role. Your special needs trust will literally be written in a way that says a care management organization will be found and hired and paid for from the assets in this trust. And if that involves companionship, taking my child to the mall, take him to the ball games, to plays, whatever they enjoy doing, it'll pay for the companionship services. If their siblings are on the West Coast and they're here in Chad's Ford in a home or in a house with roommates that they're comfortable, and your other siblings can't literally check in on them every week, the care management organization can do all that. If you're aging and you physically can't do these things, the care management can step in and give you some respite. So if you're in retirement and you want to go on a vacation, and you'd want to know that there's somebody that you can rely on when you're on vacation, these care management organizations can do that. There's a lot of really neat roles that they can provide. So now on the fun part, stuff that I eat, breathe, and sleep on a daily basis, which is the financial side of this. I mean, is anybody in here retired yet? No? Who all wants to retire someday? So sooner than later. All the things that we're doing financially, where we save, how we purchase insurance of different types, all roads are eventually going to lead to our retirement, right? So if we want to retire on our timeline and most importantly, stay retired, nobody in here, I would imagine, wants to be a greeter at Walmart at 80 years old for running out of money. We need to look at, all right, how do we finance all of these things we're going to do before retirement, such as, travel, pay off our debt, pay for education for our children if it's private school and college, then retire, and then live off our money for the rest of our lives, and hopefully never outlive it, and fund a special needs trust adequately. How do you do all of that? So it's not easy, but again, it's not rocket science. It's just knowing what goes into the planning and that we're saving in the right types of vehicles that won't be tax disadvantageous to our children if we're going to fund that trust when we die. Because everybody know there's taxes due when we die. There's the things we can't avoid, death and taxes. So if you want to take a picture of this slide, this is your quick tutorial of taxes, and then I will wrap up in 10 minutes. So this is my most fun slide about this presentation because it's the most eye-opening. Everybody here is a Pennsylvania resident, right? I would imagine. So in Pennsylvania, I want you guys to write down a couple numbers. You want to write down these different asset classes and then write down some of these numbers. So the first number I want you to write down is 0%. Okay? And then I want you to write down 40%. And just round it up, say $5.5 million / $11 million. All right, then I want you to write down 4.5%, 12%, 15%, and let's call it 25 to 40%. All right, so 0%, 40%, $5.5 million / $11 million, 4.5%, 12%, 15%, and 20 to 40%. Does anybody know what any of those are? All right, so 0%. That's what we would all like to pay in taxes, right? The 0%, if you are married and United States citizens, there is an unlimited marital deduction, spouse to spouse. There are no taxes you pay leaving assets to your U.S. citizen spouse. That's the good news. All the other numbers are bad. So the 40% is the federal estate tax. The federal estate tax is levied by the federal government on your estate when you die. And it is taxed on estates if you are a single person above $5.5 million. And if you are a married person, because you can combine your exemptions, $11 million. So good news, bad news. If you don't have over $11 million right now, there will be no federal estate tax on your estate. If you have over $11 million, good for you. Congratulations. Now, that law has changed numerous times in the 11 years I've been doing this. It started at $1 million when I started in 2005. It's gone up, went away for 11 months, and then just has been increasing since then. They picked these numbers out of a hat, I believe. But it doesn't matter what the law is right now. It is the law that's in effect when we die that matters. But right now, majority of Americans are not subject to a federal estate tax. The other taxes, this 4.5%. Anybody want to take a gander what that is? The state we live in, Pennsylvania, levies a inheritance tax on our heirs, not on our estate, on our heirs. So that 4.5% is lineal heirs, parent to child, grandparent to grandchild. We are paying a 4.5% inheritance tax on anything we inherit from anybody that's not our spouse, that is a parent or grandparent. That counts everything. The federal estate tax, take a step back, counts everything up there. Life insurance you own and all the tangible assets. Pennsylvania counts everything up there with the exception of life insurance. They don't care how much life insurance you own right now. They count everything else. No exemption, so it's from $1. So 4.5% parent to child, 12% sibling to sibling, 15% everybody else. So if you have aunts or uncles that plan on funding anything or giving assets at their death to you or to your children, and they live in Pennsylvania, they better be aware of that inheritance tax that you're going to have to pay. And we can't escape it. If we have assets in our name when we die, our heirs will pay a 4.5% inheritance tax. It's not bad, but it's still 4.5%. If we live in New Jersey, they charge 16% as an estate tax. So we're not a bad state to die in. Florida and Arizona are good ones to die in too. They don't have an inheritance tax. The 20 to 40% is roughly our income tax brackets. So when we die in the form of taxation, those are the estate and the inheritance tax. Everything else up here, if you own property, you die, there is no income tax or capital gains tax. If you own an investment portfolio that's not a retirement account, there's no income tax or capital gains tax when we die. On Roth IRAs, which grow tax-free, there are no income taxes at all or capital gains. On pre-tax accounts, so any teachers in the room, your 403Bs, anybody that works in the private sector that has a 401k, anybody that works for a governmental agency that has a 457. These are all accounts where we put money in pre-tax. We're under the guise that we're saving taxes. No, we're just deferring them to a future date where we don't know where income tax rates are going to be. So these pre-tax accounts, we're just kind of deferring this income tax down the line. kicking the tax can down the road. When we leave these embedded income taxes to our non-spouse heirs, guess who gets to pay the income taxes? Our heirs. So right now, under law, they can do three things. They can, take it all out in 1 year and pay the income taxes on the entire amount, which is not the best idea. They can take it out over 5 years in equal installments, or they can stretch it over their lifetime. Either way, they can't avoid the income tax. Congress last year talked about getting rid of the option to stretch it over your lifetime and do it over 5 years or over one. But let's say you leave a $500,000 403b or 401k to your child, and they want to spend the money. They want to spend it. They have to claim it as income, which means $500,000 gets put on top of their ordinary income. That's right that's at the top of the tax bracket. 40% in income taxes. Oh, and a 4.5% inheritance tax. 45% of the assets we work very hard to accumulate. It's gone. So do we really want to leave one of these accounts behind? No. So we better make a decision on where we save and where we accumulate to not only think about taxes today. We're all guilty of this. We live in an immediate gratification society, right? I'd rather not pay taxes today. But where do you feel tax rates are going to be when you retire? Does anybody have money on lower? Nobody. Who thinks taxes might be higher in retirement? Who thinks there's not going to be any taxes? Because I don't see any hands being raised here. Look, we've got a very, very large federal deficit. It does not get fixed by lower taxes. So sometimes we invest in these accounts figuring we're going to be in a lower tax bracket in retirement because our income needs aren't going to be as high. Do the calculations yourself. It is not true. Successful people, number one, do not end up in lower tax brackets. And even with inflation, if you need to live off of $100,000 today, in 20 years, you're going to need to live off of $200,000. So even if they keep brackets the same, you're going to get pushed into higher brackets because of inflation. So if you want to write down, there's 3 T's of taxes: today, tomorrow, and the transfer to your children or your heirs. So you want to minimize them as much as you can across all 3. So again, where we invest, the type of accounts, you can fund a trust with any of these things: investments, investment real estate, your primary residence. We just want to come up with a mix that has the least negative tax impact. So for your children with special needs, good assets to leave to them are your taxable investments, your Roth accounts, and your life insurance. So your other heirs, when you decide how to equalize your estate, they can get the pre-tax retirement accounts. Those are better assets to leave behind to them. So when you decide how you're going to carve up your estate, if you have 3 kids, if it's a third, it shouldn't be a third of everything. It should be the right assets going to the right people or trusts. Make sense? All right, so again, you need a funding strategy. You got to kick into the taxes, because if you have a special needs trust and that's it, and you don't have a defined strategy to fund it someday, and there's not enough assets that go into your special needs trust to provide for lifetime care and quality of life, all that trust is going to be is this: paper. That's not actually going to get used the way you want it to be used. So you need to have a way that you're going to fund it that's not going to disrupt your retirement. And that's what makes this planning much different than your traditional planning. So, all right, I'm going to end it there, and just really quick on beneficiaries, your attorneys and your financial advisors, this is where they need to talk, that all the beneficiary designations on your IRAs, your retirement accounts, and your life insurance are coordinated with your estate plan. So that's a lot of information. I'm sure your heads might be spinning from here, but I'll just leave some time. I know these ladies want to have a couple other thoughts, but we'll be here for questions afterwards. If they're till 7:30. If you have any questions right now, I want to open the floor to everybody. But just by a quick show of hands, just respectful of your time, if anybody needs to leave, did anybody learn at least one thing? Please share the information with other families. They need to be aware of these things before their kid turns 18, before their children turn 22. And you see a lot that transition age family of between 14 and 21, the light at the end of the tunnel is coming for them. And if they procrastinate and we're getting close to an 18th birthday, some of these strategies to protect government benefits are harder to utilize. So we need to do it as soon as we possibly can. So our busy season, where we'll be speaking pretty regularly throughout the 5 county areas coming up. If you want to be added to our email distribution list, we also have a Facebook group where we share different events. Groups like this on there. Please find us and like us. If you don't know what like us means, then I can give you a tutorial on the Facebook side of things. But there is a conference coming up next Friday. Anybody that has a child afflicted with autism, Autism Delaware and Devereaux are doing a conference down in Wilmington. That's on Friday the 30th. Out in Downingtown, they're doing a camp out craft beer. If anybody likes craft beer, Camp Out for Autism on Saturday the 1st. Pretty cool idea. But there's a bunch of these things going to be going on here over the next couple months until Thanksgiving for you guys to get out there, get some of these resources. And we like to share as much of this with the families that we meet. So thank you guys very much for your time and for your questions.
Thank you, Pat. Does anyone have any questions for Pat that you want to ask in front of the group? Or okay, great. So,
Quick question.
oh, go ahead.
So, one thing like, you have not mentioned about is the life insurance. Because what I heard and I'm preparing for is most, they tell us that if you have a life insurance, that's the only thing not taxable.
If it's owned correctly, yeah, it is not income taxable. It is not inheritance taxable. It is part of your federal
Doesn't
estate.
count for the individual's asset.
If you own it, it's part of your assets, but it is not taxable in the state of Pennsylvania. The federal government does count it for the federal estate tax as part of your estate. If you are a non-U.S. citizen, then you could be opening up a can of worms owning your own life insurance. So, but yes, life insurance is, there are some experts that consider it the biggest tax loophole that the IRS allows us to do. It's how the wealthy stay wealthy, pay their, you have $50 million. Your estate's going to be subject to a tax. The government doesn't care if it comes from a life insurance company's check or from your assets. They're going to get their money either way. So the government doesn't mind these very large life insurance policies that they get their tax bill paid from. It's the most efficient way to transfer wealth. There was I found it a funny article, which said, "Don't leave your kids any money." That was the title of it. And I sent it to my mom, and she called me 5 minutes later and said, "What are you talking about? I thought this is what we were doing." I'm like, if you read the article, it says, "Don't leave your kids any assets." If you're going to fund a legacy, if you care at all about funding any kind of wealth to the next generation, do it in a way where the government can't touch it. And life insurance is the biggest tax loophole to do that. The problem is the most misunderstood financial tool that you can use. Just like any tool. If you're a carpenter and you use the wrong tool on the wrong job, it's not going to get things done efficiently. Like life insurance, stocks, mutual funds, IRAs, these are all tools. You just need to use them the right way. A good question, either way. Anybody else have any questions? No. If you need to leave, and if you did take time to complete this and you want Lori or I to follow up with you, if you want to give it to Lori before you leave, or you can find us afterwards, you can talk to us one-on-one.
All right, I just want to say thank you again for everyone taking this time out of your evening to come and join us for U-PRISE. The next meeting is October 26th, and I did misspeak earlier. I apologize when I said that the Medical Access Coordinator, Ginny Covert, is coming in October. She's coming in November because she's coming with the BCBA Ron Masick in November because they're going to tie in wraparound services and talk about medical assistance. But if you would like help with that or information on that sooner, you can certainly email us and we can connect you with Ginny Covert about medical access. Just real quick before you leave, if you have a minute and you want to look around the room and introduce yourself to at least one other parent that maybe you don't know, one of the purposes of tonight is for you to network with each other and make new friends, and you're in a boat with these people. So you're all parents in our district, and we'd be happy for you to meet each other. Leah and I will stay around, and please don't forget to collect your children before you leave.
Two other quick things I forgot to mention is if anybody in here is entitled to a pension from your employer, if you're lucky enough to still have a pension, it is very difficult, if not economically inefficient, to leave a pension to your child with a disability. Number one, the income that they would get from the pension would disrupt their government benefits. And number two, the amount of reduction that would be caused in your pension to leave it to your child would be so large it would make absolutely no sense. So there are ways that you can leave a pension and make it multi-generational. You just can't do it through your pension. This applies to anybody with PSERS too. A pension is one of the best things you can have, and you want to make the best decision with it to get the most for you while you're alive, but also the most for your family. And selecting a pension option to leave it to your family through the pension is the most limited way you can do it. So if you have a pension, this changes even more decisions that you need to make.
Just double check. So if you have beneficiary designations going to the child with special needs, that automatically could corrupt their receiving any benefits. So basically, spouse's first contingent, and then you should basically do other children, and then any portion of theirs should probably go to the special needs trust if that's how you want to designate. Like basically get it out of their name right off.
Exactly. Any beneficiary, as long as you have a trust, of course. Your beneficiary designations are contractual law. They bypass your legal documents. So if you create a special needs trust but forget to update your beneficiaries and your beneficiaries read outright to my children, it will never go into their trust because they look at the contract, it says outright, it will go outright to them before any legal documents are read. That's where a lot of financial planners misstep with this planning. They forget to update those things.
Not to hold anybody up, but I did hear somebody talk before about transfer upon death, that it's supposed to go directly to them. Is that basically the same thing as beneficiary designation?
Yeah, it's a way to
Or
avoid
just-
probate.
Does it take it out of your estate and directly to them, or it's still includable?
It's still a part of your estate, unfortunately, but it avoids probate. Does anybody actually have to deal with probate? Anybody die in the executor or executrix of an estate? No? Well, good. It's not a job you want to do. Probate, it can be time consuming. It's emotional because you're brought back to that day you lost your loved one. Every time you have to fill out a form or you get a letter in the mail. It's all public information. People can fight over things. The assets inside of probate are more subject to your creditors. So that if you can, you want to avoid probate as much as you can. So beneficiary designations, transfers on death or payable on death accounts, other types of trusts can avoid all of your assets from going through probate. If you own a shore house in Jersey or Delaware or any other state, you want to avoid what they call ancillary probate, which is probate in more than one state. For those of you that have parents living, and you might be the lucky one that's appointed as their executor, make sure they can get as much of their assets out of probate so it makes your job easier. So, and get your parents involved. I mean, parents and godparents and aunts and uncles, when you can communicate this the right way to them, telling them there's options, that they can do things for their grandchild with a disability or their niece or nephew with a disability without jeopardizing their benefits, it opens up the conversation for them to do a lot for them.
But then if you move to another state, you have to redo it all.
Sorry, was that?
If you move to another state, you have to redo it all because it's all kind of state-based.
Your legal planning is governing federal kind of benefits and laws, so no, typically. There might be some other types of trusts you would need to create depending on the state that you live in. However, it does get tricky changing the location of your child with a disability because if they're in the county system, it differs county to county. When you go to different states, it changes a lot. So that's one of the hard things with a lot of parents that want to relocate to other states, but they don't want to take their child out of the system that they are in and getting benefits in. So that was a long-winded answer. So the easy answer was probably not, but you talk to your attorney about that. And if anybody needs an attorney, feel free to ask us. What we typically like to do is know a little bit more about you so we can mix it, match up personalities, what you need done financially before we start just giving you, blank names to look at. So,
Okay.
all right.
Thank you so much. Have a good night.